Hi, my name is Dan Dalton, and I'm an attorney at Dalton and Tomich in Detroit, Michigan. I'm a religious land use attorney. One of the most frequently asked questions clients have prior to engaging us is how long is this lawsuit going to take and how much money is this going to cost? And the answer I give everybody is the same. I can't tell you. I don't know. But let me give you some parameters. In terms of time, the typical time it is from a case from the date you file a suit until the date you get your trial date is 18 months. Nationwide, I found this to be true, whether you're in California or New York. It really, though, depends on the court's docket, on the judge that you have and how fast or slow he goes or she goes through this matter. I've had cases that have gone 6 months from the date of filing to a trial date, and I have cases that have gone for over 10 years, where we've gone through appeals back and forth, and we have trial dates 10 years later, and they're still not over. It really depends on how your case goes and how your judge acts, and more importantly, how your opponent, your city or your state or your local government responds to the matter. In that matter, you might be asking yourself, well, how much is this going to cost? Can I afford to do this type of work? When you're looking at the issues of cost and expense, you need to remember a couple things. Number one, you've probably bought a piece of land or you've probably bought a building that you can't use. And you have to make that decision up front. Do I want to spend the next 18 months to 2 or 3 years perhaps litigating this case and having my congregation be on hold somewhere else temporarily, or am I really committed to this matter? The second thing you need to know is that what Congress did is it provided that if you, as a religious use, are a prevailing party in this matter, you get all your fees and all your costs paid back. Now, it's up to the judge to decide the hourly rate to be charged and the amount of hours in terms of whether they're reasonable or not. But in a large part, your fees and costs are going to be compensated or going to be covered as a prevailing party. Does that mean if you lose that you have to pay the city's fees? Not necessarily so, because what Congress did is it provided for prevailing parties for religious uses. If you file a frivolous claim, meaning you have no basis in law or fact for filing your claim, then a municipality can file a motion to get their attorney fees back, but not if you file a good faith claim, and that's pretty much universal throughout the United States. The amount of cost is very dependent on the type of claim that you have. So you're not going to find anyone that's going to be able to tell you it's going to cost X dollars or Y dollars. But there are certain ranges in terms of where you're at and what your costs are going to be based on your case. That requires an evaluation of the facts of your case by an independent attorney that knows this law and knows the judge and knows the jurisdiction you're in to give you an idea of that amount of money. If you have any other questions about the expense or the time that it takes to litigate a religious land use matter, or if you have questions in general about religious land use and zoning, feel free to reach out and contact me or go to our website, attorneysforlanduse.com, where we answer a number of these questions throughout our resource pages. Thank you for watching.